So last week we spoke about the new OCC FinTech charter and some of the advantages and disadvantages for FinTech companies in pursuing one. And we've received questions about how that process works. So today I want to talk about the 4 phases of the charter application process, which is a pre-filing phase, the filing phase, the review phase, and then the decision phase. And each of these are formalized within the OCC's guidance. So the first phase of the application process for a FinTech charter is the pre-filing phase. And a lot of companies think, well, that should just consist of Googling OCC, figuring out what their address is, and then we can engage in the filing. But it's not that simple. The OCC encourages all applicants, whether they're banks or FinTech companies, to go through a pre-filing series of meetings and interviews with people at the OCC. And for FinTech companies, those initial meetings are with the OCC's Office of Innovation. After that, there will be meetings with the OCC's licensing department. And the purpose of those meetings is to give the applicant a chance to get some informal feedback from the OCC and be alerted if there are issues of concern with the application. And it also gives the OCC a chance to get a better understanding of how the business works. So when it first reviews the application, it has that background in mind. And the meetings are actually pretty detailed. You go through the business plan, the proposed activities of the business, the marketing analysis that's been done, how the applicant intends to comply with capital and liquidity requirements. And sometimes there's even an informal submission of a draft application. So the OCC can give the applicant some feedback before the final application is submitted. The general procedures for filing an application are the same for a FinTech company as for any other bank that's trying to get a charter from the OCC. So you submit the application itself to the appropriate licensing unit of the OCC, which is either the district licensing or it can also be headquarters licensing. In addition, a notice needs to be filed by the applicant in usually in a newspaper that is circulated wherever the company is going to be doing business, and then the application itself needs to be submitted. And that includes business plans, explanations of how it will be complying with various laws and regulations. And one thing that kind of surprises a lot of applicants is it includes a lot of information about individuals who are going to be involved with the institution, whether it's directors, management, and that includes submitting fingerprints, permission for the OCC to run a background check, a waiver that allows them to access tax records. And the OCC really thoroughly vets those individuals, both that type of general background and their specific background within banking. And then in addition, there's all of the various submissions that have to do with supporting whether or not the bank will ultimately be profitable, whether or not it will be complying with consumer laws and applications, and a detailed explanation of the contracts that the bank will have with various third parties, because the OCC is always very concerned with whether or not the third parties that will be assisting any FinTech company with complying with the law has the appropriate level of skill and experience, and whether or not there's any risk that is created to the FinTech company by virtue of the nature of that third party. So after an application is officially submitted, the review phase begins. And that's really outside of the control of the applicant, although there's some back and forth between the OCC and the applicant when they have follow-up questions about statements that are made in the application. And the OCC is looking at a number of different things. One of the main focuses, of course, is whether or not there's a reasonable chance of success for the FinTech company. If there's not, they don't want to give it a charter. They also look at whether or not it's going to be complying with laws that have to do with protecting consumers, whether or not the consumers will be treated fairly, and also whether or not the company will be giving fair access to different people that might want to make use of the services. They focus on whether it'll be complying with other laws and regulations. These include the Bank Secrecy Act, which focuses on money laundering, whether or not it has systems in place to comply with the OFAC requirements for screening individuals who might be involved in terrorist financing and transactions to and from countries that may be involved in activities like terrorist financing. And they look at the service providers, both with respect to whether or not those service providers will be able to provide the services and what the risk is to the institution if the service providers have a problem. And one of those problems is cybersecurity. So they'll evaluate cybersecurity for the applicant itself and any service providers, any third parties that are outside of the company that might have access to sensitive information of the company. So the decision phase isn't just a simple thumbs up or thumbs down. As with each part of the process, there's sub-phases. There's the preliminary conditional approval phase, and then there's final approval. And the conditional preliminary approval is really there to give a signal to the applicant that after review, it looks like the OCC thinks they'll be able to go forward, and then the applicant can go out and actually start spending money, whether that's engaging in fundraising activity, hiring people that are going to be in management. But it gives them a chance before they make that major financial investment to get preliminary feedback. But the preliminary approval, while it comes with authorization to organize, isn't an assurance that you're going to get final approval. And during that phase, the bank starts to organize, and only after that is final approval given. And even with final approval, that comes with some strings attached. Often the final approval comes with a requirement that a bank comply with various conditions. One of those conditions is typically not deviating from the business plan that had been submitted in connection with the application itself. The process of applying for a FinTech charter can be time-consuming and even expensive. And FinTech companies in particular usually want to move quickly. And so to do that, it's really important to line up advisors as quickly as possible that are familiar with the banking regulatory environment and the type of documents that the OCC will expect to see in the format that they expect to see, and line up a slate of management as quickly as possible that have adequate banking experience, and get all of the documents both concerning how the FinTech company is going to operate and its business plan, and think through how that entity is going to comply with the various consumer compliance laws, OFAC requirements, BSA, AML requirements that the OCC is going to be asking them about. And if you have those advisors set up front, who are familiar with banking laws and how they work, the process will go more quickly and much more smoothly.